Well, an absolute bombshell was dropped today in the Karen Read case. If you were watching the hearing and following along, then you know exactly what I'm talking about. All of a sudden, in the middle of the hearing, all these motions, there's a lot of motions that they had to get through. And when it came to the ARCA expert motion, which was filed by the Commonwealth to exclude the ARCA experts, all of a sudden, after Hank Brennan was done arguing, Judge Cannoni said, we have to take a break. She went off the bench. She came back and she said, there are many ramifications because of what I just heard to the defense and the defense counsel. And therefore, we are stopping this hearing right now, and we are going to be coming back in about a week. And that's when they are scheduled to come back in a week to finish off this hearing. So what exactly are the ramifications? What can this possibly mean for Karen Read? What does this mean for the ARCA experts? So we're going to explain all that today. So first, let's go through what happened. It's not that long of a clip. I'm going to play for you what Hank Brennan argues, what he alleges, and we are going to see that Alan Jackson did not even get a chance to respond. And we're going to talk about that as well. So the only thing that's a little bit complicated a little bit confusing, I should say, to really nail down is what exactly was provided by the federal government and what exactly was provided by the defense counsel. Because it seems at the end of the hearing, he kind of seemed to say that a lot of this was actually provided by the defense counsel. So this is the defense counsel themselves providing some of this information. I don't think it makes so much of a difference because really it comes down to one part of the argument, which Hank Brennan was talking about. Okay, so let's play it again. We're going to break it down, and we are going to explain everything when we're done. So here we go.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So that he was reading from the transcript in the previous trial. This was on June 10th, 2024. They were talking about whether the ARCA experts are going to be able to testify. And what the defense has represented. He didn't say who was arguing, but I imagine that this was Alan Jackson. That what the defense was saying is that we cannot provide them any discovery about these ARCA experts because the federal government does not allow us to collaborate with them, does not allow us to interview them. We cannot have any conversation with them. The only thing we've spoken about is about logistics, briefly about qualifications, but no substance of their testimony. We have not discussed that with them. So we can't have any reports from them, and therefore we can't provide this to the Commonwealth. That was what the defense was saying, and that is why Judge Cannoni eventually said, okay, very nice that you can't, but since you can't, then that is a Rule 14 violation, and exactly what she's going to be doing with that, that's what she did in the last trial. She did allow them to testify. They had a like a mini Daubert hearing, that type of thing, voir dire, but that was how she dealt with it then. So you see what the defense's position is back then in the trial. We had no real communications with them. There's no strategizing. We didn't talk about strategy. I didn't talk to them about what questions I'm going to be asking them and what answers they're going to be giving. None of that. So now let's see how he continues.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed in over a long period of time with requests and deadlines. I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery.
So here it seems to be that he's about to tell us what he's received from the federal government after TUI requests and following up. And finally, he got some materials from the federal government. So that's what it seems to be. That's his representation, at least now, to the court, that these are the materials that he got from the federal government that has to do with any sort of communication between the defense and the ARCA experts. So listen to this. Now, keep in mind that Alan Jackson, it seems, I don't remember exactly if it was him, but I think it was, represented to the court, which you just read in the transcript, that there was no communications about the substance of their testimony. So now let's listen to what he has to say now.
Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with.
So that was just the recent emails that they sent to the ARCA experts. He has no issues with that recently, so that's fine.
But if we look back earlier in the relationship.
But looking back, that's where he cares about. You're allowed to have contact with the ARCA experts now. Now you can have contact with them, no problem. Because we're going to see that the federal government terminated their contract in February 2025. So now you can. Now it's fair game for anybody. But this is going back when officially you're not supposed to have any contact with the ARCA experts, definitely when it has to do with the substance of their testimony.
What we see back in March 22nd, 2024.
So that's an important date, March 22nd, 2024. These are the communications.
Is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith along with your retainer as required.
So what that email is that send me your engagement letter, which means send me your agreement, what I have to pay you in order for you to testify. And then we'll get that signed. We'll have like this contract between the two of us. We'll get that signed. And then we will send you your retainer, right? Your retainer is the first payment. There's different payments throughout the process. So we will send you your retainer. Now, this is in March 2024, which, from what we understand, they were not hired by the defense. They were hired by the federal government. But here it seems from the email. Now, again, we don't know what happened much more after. We don't see any checks that were written quite yet. But this is some sort of communication. Now, could this be just a misunderstanding by Jackson, that maybe he thought that they could hire them, but now he realized that he can't hire them, and maybe there's some back and forth about that? If not, then this certainly looks like, here, we're willing to hire you and pay you for whatever's necessary. So is this on the side beside what they already hired with from the federal government? I don't know. But what we do know, at least just listening to this email exchange, assuming that he's representing it correctly, this is in March 2024, when they were definitely still hired by the federal government. And it's Alan Jackson responding to Dr. Wolf, let me know what, send me your engagement letter, your contract, and then I will send you a retainer, a payment.
Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information.
So he's saying this information the Commonwealth had no idea about. They had no idea about that email between Alan Jackson and Dr. Wolf about the offering to get paid.
Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward.
So that's Dr. Wolf responding that we can't have any more communication about that, which would seem to suggest that there was no engagement that was signed, there was no retainer that was paid or anything like that.
Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can.
So that email seems to be what he's saying now is from the federal government. So that email from Dr. Wolf to Alan Jackson, telling him and complimenting him about his questioning during the voir dire. This is June 22nd, 2024. He's saying, let me know if you have any other suggestions. Sounds like there's some level of collaboration there. And he's saying that this was never turned over to the Commonwealth, though these emails back and forth between Dr. Wolf and Alan Jackson. They only got this from the federal government.
We then are provided an outline.
Now, he says we are then provided with an outline. I'm not exactly sure if this is from the federal government or from the defense counsel. So that's my only confusion here, because it seems like he says at the end that this outline was provided by the defense counsel. But here we have the outline nevertheless, and it seems that this outline was sent back and forth back in 2024.
Of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody.
So you have the outline of the direct examination, which is common. When you are preparing to direct a witness, to question a witness, you have an outline. So it seems that Alan Jackson had this outline prepared, and it was either sent to Dr. Wolf or they were talking about Dr. Wolf, and then Dr. Wolf put some of his notes on the side of this outline. So again, it looks like here, these are the questions I'm going to be asking you. Do you have any suggestions about what I should be asking you or what I shouldn't be asking you, anything like that? So again, there's a level of collaboration here, and the Commonwealth never knew about it.
So we see in the margins in the notes, this fair-minded, objective witness says,
And you can really taste the sarcasm and how he's saying that.
so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure.
Now you hear about that. He's talking about inspecting the actual vehicle. So they knew that this was coming. They knew that that's a fair line of cross-examination. You didn't expect the vehicle, which is what we keep hearing from a lot of the people who think that that's an important issue, that the ARC experts did not actually inspect the vehicle. So here they were just talking about this idea about whether that's true. Is it like common in your line of work to not inspect the vehicle? And he said, yeah, of course that's common. And it is common. Now, we have to remember that it's not really so much the substance of what they're talking about that means that they're not credible. That's not what this is, what the allegations here. The problem here is that none of this was turned over to the defense. That's what Brennan's problem really is. So again, this is normal. It's okay. It's not like Dr. Wolf's lying now and saying, oh yeah. It's very important to see the vehicle, but I'm just going to lie. That's not exactly what's going on here. He's saying, yeah, it's common in my line of work to not see the vehicle. There's no reason that he's lying. He's not lying.
Sure, if you want to put this somewhere in the direct examination, I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
And so this is what Dr. Wolf is saying, like, to Alan Jackson. This is one of the things that they may bring up, and it's really not an issue, which it really isn't. But the point is that you're seeing a level of collaboration here between the expert and the defense. Now, before we go on, just something that's important for everybody to understand is that this is very common. It's very, very common to have an expert who you pay and who you collaborate with. It's very normal. It's very common. And your expert gets up there and testifies. And it doesn't mean that because you're paying him that he's lying. It does show bias. So the other side can definitely argue bias. That's true. Oh, how much are you paying him? Oh, we're paying him, $20,000. Oh, well, don't you think that you're going to want to, make the person who's paying you all that money happy and testify in his favor? So sure, you can make that type of argument, and that argument's made every day in court, every single trial, because in 99% of the time, 9% of the trials, you have experts that are hired by both sides. They have their experts that they hire, and you have your experts that you hire, and you have battle of experts. This happens every single day in trial. And they argue that the jury shouldn't believe your experts because you pay them, and you argue that the jury shouldn't believe their experts because they pay them. That this is all part of the game. Okay, so it's what's going on here. The fact that there's collaboration in of itself is not crazy. This is very, very normal. It happens in every single trial. The reason why in this case it's very different is because Alan Jackson has been representing the entire time and arguing to the jury that he had absolutely nothing to do with these experts. And these are completely 100% independent, objective witnesses. That's more the issue here than it is the actual issue of, oh, wow, someone's paying an expert. That happens in every case. Or, oh, wow, look, there's collaboration between the expert and the person who's paying them. Of course, that happens in every case. But the point here is that they represented that they have nothing to do with this, and they're not doing this, and now we're seeing that they are doing it. Or there was some level of collaboration between the two.
Yes.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now,
see, with that response, it sounds like he's saying he got this outline from the federal government, because he's saying we sent the TUI request in February, but they sent a bunch of documents back. So it could be it's the outline we got from the federal government, but I think later he's going to take that back. So the point is that if this outline was done in 2024, as they are preparing for Dr. Wolf's testimony, then it has to be turned over. and you shouldn't make an open representation to the court that none of this happened. That's Brennan's point here.
I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So,
all right. So, this is a point where Dr. Wolf is talking to Alan Jackson, talking about, his work and evaluating and doing some reconstruction about pedestrian strikes. And he said that, yeah, a lot of them happen at night, which is pretty intuitive. You think at night, people's visibility is not that great. And there are probably more accidents involving pedestrians at night. So that's true. Okay, now this was at night. So this is something that the defense the Commonwealth could have brought out on cross-examination. They could have said, Dr. Wolf, isn't it true that most pedestrian strikes happen at night? Oh, okay, fine. Yeah. And now, they can argue to the jury that this is also, pedestrian strike at night. It's not going to take away from the fact of their ultimate conclusions, which is that, the damage to the vehicle and the injuries, I don't care if are not consistent with each other. So it's ways to argue for the Commonwealth. These are different, things that he would have liked to have in the first trial. Again, he wasn't the prosecutor, but the prosecution would have been like to have to kind of bring out and make an argument to the jury. It shows bias, but not that it completely destroys everything that the ARC expert testified to. Not at all.
my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
So again, it just shows a collaboration. Like if he's telling them, look, if you don't want me to talk about the pedestrian strikes at night, I want us to talk about it. If they bring it up on cross-examination, I'm happy to talk about it. But it's up to you. You want to talk about this, and this is just like typical collaboration between an attorney and an expert. So that's all he's trying to show here. Again, all he's trying to show here is that there is some level of collaboration between the expert and Alan Jackson, and therefore he shouldn't represent to the court, or at least number one, that he should have turned the stuff over. Number two is that he shouldn't represent that none of this was going on when it really was going on.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
So testifying in 20 trials is different than testifying in 11 trials and 7 depositions. Obviously, that's a little bit different. Less experience. So that's something, again, cross-examination could have brought out. But then again, it said, okay, I don't know if you want me to clear that up or not. All right. But again, a level of collaboration there is.
And then a bill from ARCA to the defense for $23,925.
So there's a bill. Now the question is, when did this bill come? And again, he's talking about a lot of different documents that he got. This could be the recent bill that he got, that the defense is turning over from them engaging ARCA for this next trial. So we don't know. It's not clear, at least to me, whether this was a bill that was sent to them from last trial, or this is a bill that was turned over to him as part of the disclosures for this trial. That does not seem to be clear. Again, you can infer from here that he's talking about what the federal government gave him, which again, later is going to walk some of it back. So it's just not 100% clear exactly when this bill was given to him and if this bill was paid, and if this was a bill that was paid in 2024, or this was a bill they're going to be charged for the next trial.
That's not Tramble. That's not trial by ambush. That's getting duped. So
just to understand that argument, right? Everybody always likes to argue when you're an attorney that there's trial by ambush, which is that you're surprising us. You're just springing an expert on us on last minute. That's trial by ambush. Or all of a sudden you're coming up with documents that you never turned over to us, and now you want to present it as part of your case. Trial by ambush. We've all heard trial by ambush. So what Hank Brennan's arguing here is that this isn't trial by ambush. This is far worse than trial by ambush. This is being duped. This is so unfair that you don't even get to argue trial by ambush because it's so much worse than that. That's kind of what he's saying here.
I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial.
No, that's not true. Okay, that's not true. Okay, he definitely cares. He does not want the ARCA experts to testify. I mean, this is an argument that he's making, but he absolutely does not want the ARCA experts to testify. Even if you have all this fodder for cross-examination to show them a $22,000 bill and to show this collaboration between Alan Jackson and, to show all this stuff, he doesn't want the ARCA expert testifying. That's definitely true. Okay, but in support of his motion here, he's saying, look, I don't care if they actually testify. I just want this to be fair. Just turn over the documents that you're required to under Rule 14. And that's his argument. So it sounds a lot more genuine.
I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
Did you hear his last point there? If they can produce the discovery, I'd welcome ARCA. Okay, we'll come back to that later.
All right, I'm going to take a recess before the response.
I see. So the judge takes a recess right after this argument. Not hearing from Alan Jackson at all. She's not hearing anything. And she takes a break, and we're all just sitting there waiting. So I'm going to jump ahead to where she comes back. And just listen to what she says when she comes back.
So she may be seated, enjoy cell phone off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
It can have profound effects on the defense and defense counsel.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today.
All affected will be appropriately prepared. I'm going to explain to that what that means in a minute also.
At 11 o'clock in the morning, you can tell me now if that is impossible for you. Authorities have been kind enough. Would you be kind enough to, in fact, get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of.
Okay, so now he's just going to finish off, and then we'll cut it off, and I'll just explain a few more things.
If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th,
See, now he's saying that it was the defense who provided those emails.
2025, they sent us the emails and the direct examination outline.
So it sounds like now it was all provided by the defense. I'm not exactly sure what was provided by the federal government.
We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so
Okay, so that's that. So February 6th is when the contract with ARCA terminated, and that is a few days later, if it was February 12th or 13th, that's when the defense reached out to them to engage them. So there's nothing wrong with engaging them now. So again, I don't know when that bill was from, and I don't know exactly what he got from the federal government, what he didn't. But let's just get to the main issues here, okay? There's two issues. Is ARCA going to be excluded? And what are the ramifications for Alan Jackson? Okay, they're two separate issues. Now, if Alan Jackson represented to the court something and it was a lie, he's not in a very good position. Okay, that's not exactly the position that he wants to be in. Why didn't Judge Cannoni allow him to respond at all? Well, the reason is that she was suggesting that all parties that are affected can be properly prepared, which means that he should lawyer up. It's like a hint for him to say, get your own lawyer. You may want to be represented and not say anything that may harm you. Okay, so that's what she was doing there by not requiring him to respond. And if she may have required him to respond, if she would have said, would you like to say anything? He may have said, well, Your Honor, maybe we should break and maybe I should, have a sidebar or something. And then, they would have talked about this then. But that's essentially what she was saying to him, in my understanding. He was saying the defense and the defense counsel, meaning the defense counsel should get represented. Now, remember that Alan Jackson is pro hoc. He's not licensed in Massachusetts. He's licensed in LA and in California. And therefore, he's at the pleasure of the court to be practicing in front of that court. So if this all pans out and he actually made a representation to the court, and there's no good explanation for this, that he was saying that there was no collaboration, they had nothing, and then he suppressed this information from getting to the Commonwealth, and this was with intention, then he's not going to be practicing in Massachusetts any longer. So it's it could be likely that he's off the case. Okay, now this is a little premature because we don't know what's going to happen next week. But if this all pans out, it can be a reasonable possibility that he's going to be off the case, Alan Jackson, which would probably mean Elizabeth Wood was also going to come off the case. So that is what Alan Jackson is facing. He may be facing some sanctions. He may be facing some disciplinary actions. He can be facing some stuff that he doesn't want to be facing. Okay, if this all pans out. Now, what does that mean for Karen Reed? Okay, let's talk about Karen Reed now, because these are two separate issues. Whether a lawyer himself or herself lies to a court or misrepresents something to the court, then there can be some disciplinary action taken against that lawyer. So again, it's too early to say if anything's going to happen, but it seems that that's what Judge Cannoni is suggesting, that he should lawyer up. Okay, so that's probably what we might see next week, that he'll have a lawyer talking for him in this proceeding. That may happen. In terms of what's going to happen with Karen Reed. So now here's the issue. This is all talking about last trial. Okay, last trial's over. This is last trial. So maybe you want to argue, oh, this wasn't fair for last trial. Well, now what? What are you going to do about last trial? Okay, so it's not fair. Now we have a new trial coming up. So make it fair for this trial. So are we going to allow an attorney's actions that he took in a previous trial affect a new trial coming up? That's a question. So the most reasonable answer would be no. Just because some attorney maybe misrepresented something on, even if it's, how is Karen Reed supposed to know? She's not a lawyer. And maybe she didn't know about all this stuff. So, this is just Alan Jackson acting on his own. So why should that affect Karen Reed? And now you're not going to allow the ARCA experts to testify. What does it have to do with Karen Reed? Now, there is a remedy that if you don't turn over what you're required to under Rule 14, then that could mean that the court can exclude those experts from testifying. The court can preclude them from testifying. That is a sanction. That's a remedy that the court could decide to impose. But is that the appropriate remedy here? That's the question you have to ask yourself. By Alan Jackson, conduct that he took in last trial in 2024, should that mean that they should not be allowed to call the ARCA experts in 2025 when the trial's not still for another month and 6 weeks? So you can still turn over all information that you want. You can still turn over and have disclosures, and they can be completely prepared for trial against the ARCA experts. So that's one possibility. Judge can say, look, Alan Jackson, we're going to sanction you. You can't practice in this court anymore. Maybe they're going to refer to the California disciplinary bar, or the committee, that they can do that. On the other hand, what are they going to do with Karen Reed? Well, what she could do with Karen Reed, which would be reasonable, is to say, we're sorry that you had this attorney who lied to us or misrepresented something to the court. I mean, let's just say that happens, if that pans out. And I don't want to take anything away. Everybody's innocent until proven guilty. We heard some things today, but we haven't heard, due process requires for, everyone to be able to argue their case. So we don't know what Alan Jackson's story is going to be. Maybe he has a great story. Maybe he has a good excuse. Maybe there's some things taken out of context. We've seen this before. So that's, but let's just assume that he gets thrown off the case. So then what is this going to mean for Karen Reed? Whether the ARCA experts are going to get excluded. So number one, it's very reasonable that they won't get excluded, and they'll just turn everything over now. It's plenty of time before the trial. What's your argument now? There's no trial by ambush at this trial. Maybe you can argue in 2024 there was trial by ambush or duped, whatever you want to call it. But right now we have a new trial coming up, and we'll give you everything that you want. We'll give all the disclosures, everything that was required under Rule 14. Okay, look, that's one reasonable option, I think. But let's take it to the most drastic. The most drastic is, let's say Judge Cannone says, we're not going to allow ARCA to testify. There's been a Rule 14 violation. We're not allowing them to testify. Now, that's not Karen Reed's fault, right? Whose fault is that? If Judge Cannone decides that the ARCA experts are not going to testify, that's Alan Jackson's fault. Which means now what you're doing, if Judge Cannone grants this motion now to strike the ARCA experts, and it was all an attorney's fault, and these ARCA experts, everybody understands how incredibly important they are to Karen Reed's defense, and now they're off, well, then now Karen Reed can have a very strong, legitimate claim of ineffective assistance of counsel. Okay, and then the case can be reversed because of that. So is that what Judge Cannone wants to do? Now, she may say, look, I'm done with these games. You're not having ARCA. Now, and I don't care about your claim of ineffective assistance. And maybe they'll go through the trial, and maybe she'll get convicted, Karen Reed, if they don't have the ARCA experts. And if they don't have the ARCA experts, then there's going to be an appeal filed. And part of that appeal, if the ARCA experts don't testify, is going to be a claim of ineffective assistance of counsel, which in this case should be clear cut if an attorney was intentionally withholding this information. And if he gets some sort of sanction and get thrown out of the court because of it, you can definitely have a very strong argument of ineffective assistance of counsel, and maybe the case is going to be reversed and have to be tried again for a third time. Is that what Judge Cannone wants? But that's another option out there. Okay, so those are the two different. Those are the three options. Jackson can get thrown off the case, can get sanctioned. ARCA experts can be excluded from the case, and then there'll be a claim of ineffective assistance of counsel, or the ARCA experts will testify, but they'll be able to bring out all this information that Jackson was collaborating with the expert. Now let's go through that scenario. Let's go through the scenario that the ARCA experts will be allowed to testify. Jackson's off the case, so maybe it'll be Anetti or Alessi or Mark Bettero. They'll be doing the opening and closing and cross-examining the witnesses, whatever. And then they bring these ARCA experts, and the ARCA experts testify, and then you'll hear Hank Brennan cross-examining these experts, and he'll be able to bring out all this information. And really try to attack these ARCA experts' opinions. Now, that's what happens in a lot of trials. Okay, I've been in trials where experts are really attacked. Sometimes I attack experts, and I'm able to punch some holes in them. Nevertheless, their ultimate opinion here is extremely, extremely credible. Because even if you're going to argue all these things, you're going to say, oh, you're biased, you're this and that, the other thing. Are you going to get up to the stand and lie through your teeth? Are you going to just right out say that this is against the physics and science when it's really not? Sometimes you can get experts to kind of push your case a little bit stronger. When there's a questionable call, they'll go in your favor. You're not going to get an expert to straight out get on the stand and lie through their teeth. That doesn't happen. You'll get an expert to say, yeah, this person's not as injured as they claim to be. They think they're injured. They're really not injured. Or this fracture is not as serious as it seems to be. That type of testimony. They're not going to say, for example, that there's a fracture there if on the x-ray there's no fracture. They're not going to say that. So it's the same thing over here. For them to get up and say, that based on the science and the physics, nothing adds up, and this is all straight out science. They're not, that's going to be much more difficult for them to say, even if they're hired, even if they're getting paid $23,000. And that's much more of a common argument that we heard. Oh, they're biased, and that's in every trial. So those are the different options I think that I see in front of me. So I think really the person who's most concerned right now should be Alan Jackson, not so much Karen Reed. I think Karen Reed's still going to be in a very good position, whether the ARC experts testify, whether they get excluded. Now, if they get excluded, it may not be so nice for Karen because she may be convicted. And if she's convicted, then she's going to be sitting in prison while there's an appeal. And appeals can take years. And then you never know what an appeal court's going to do. As we saw, the SJC opinion, I wasn't so impressed with. So, who knows? Maybe they're going to find that there wasn't, ineffective assistance of counsel in this case by having the ARC experts not testify, which would be, again, beyond me. And it seems textbook ineffective assistance if you can't get these ARC experts to testify, or if you did something nefarious or intentional and withheld and didn't perform your obligations of rules and obligations under rules of professional conduct, not just the court rules. And an appellate court's not going to find that was not ineffective assistance of counsel. So I think, again, if you're in Karen Reed's shoes, it's not pleasant. You want to stick with your attorney, but ultimately, I think the ARC experts will still testify. And even if they don't testify, even if Judge Cannone strikes them, there's going to be a very, very strong claim of ineffective assistance of counsel, which again would prompt a new trial. So that could be what we're looking at. So that's my take on what happened today. Some crazy stuff. You don't see this every day in trial. And the Karen Reed case, it just keep getting crazier and crazier and crazier every single time. So that's going to be it for this video. I know there's a lot of other motions that were filed and we still have to get through them. But this is the topic of the day. So hopefully this cleared everything up. And that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.